The subject of the controversy stemmed from two civil cases filed by the parties against each other relative to a purported contract of sale involving a piece of property situated at Davos City initially covered by Transfer Certificate of Title No. T. 112717 under the name of Rosa Elsa Serrano Jonas and currently the Transfer Certificate of Title No. T. 315273 under the name of Ganzen Yap married to Jaime Yap. On July 19, 1985, before Rosa Elsa went to Australia, she had executed a special power of attorney authorizing her mother, Andrea C. Serrano, to sell the property. Cipriano Serrano, son of Andrea and brother of Rosa Elsa, offered the property for sale to spouses Benjamin and Farida Yap by showing to them the special power of attorney executed by Andrea. On September 3, 1996, Cipriano received from spouses the amount of $200,000 as advance payment for the property. Later on September 10, 1996, he received the additional amount of $400,000. Spouses sought a meeting for final negotiation with Rosa Elsa, who at that time, Rosa Elsa was in Australia and had no funds to spare for her travel to the Philippines. To enable her to come to the country, spouses paid for her round-trip ticket. Shortly after her arrival here in the Philippines, Rosa Elsa revoked the special power of attorney. The next day, the parties met at Farida's office, but no final agreement was reached. A day after, Rosa Elsa withdrew from the transaction. On October 17, 1996, spouses filed before the regional trial court a complaint for specific performance with damages seeking to compel Rosa Elsa, Andrea and Cipriano to transfer to their names the title over the subject property. While the case was pending, Andrea sold the subject property to spouses through a deed of absolute sale. Thereafter, Rosa Elsa asked Andrea about the sale. Her questions about the sale, however, were ignored and her pleas for the cancellation of the sale and restoration of the property to her possession were disregarded. Rosa Elsa, however, earlier mortgaged the subject property to Mindanao Development Bank. Upon failure to pay the loan on maturity, the mortgage was foreclosed and sold at a public auction on December 14, 1998. Spouses were able to redeem the property on September 14, 1998 from the highest bidder, Thelma Jean Salvana, for 1.6 million pesos. Spouses filed before the regional trial court a complaint for specific performance with damages seeking to compel Rosa Elsa, Andrea and Cipriano to transfer the title of the subject property to their names. In their complaint, spouses alleged that sometime in May 1996, the property was offered to them for sale by Cipriano, who showed them the special power of attorney in favor of Andrea. They sought a meeting for final negotiation with Rosa Elsa, who is the registered owner of the subject property. Regional Trial Court, Branch 13 granted the prayer for the issuance of a temporary restraining order, TRO, preventing Rosa Elsa and her agents from disposing the subject property. Rosa Elsa countered that despite her appointment of her mother, Andrea, as her attorney-in-fact/agent, she later gave her instructions not to sell the property. Spouses Jonas filed before the Regional Trial Court a complaint for annulment of deed of absolute sale, cancellation of transfer certificate of title and recovery of possession, injunction, and damages against spouses. Spouses Jonas alleged that Rosa Elsa acquired the property before marriage, specifically on July 19, 1985, when she decided to leave for Australia to reside there. She executed in special power of attorney of the same date, granting her mother, Andrea, the authority to sell the subject property. Regional Trial Court, Branch 13 rendered a joint decision directing spouses to pay Rosa Elsa the amount of 1,546,752 pesos and 80 cents, representing the balance of the sale of the subject property. The Court of Appeals reversed the Regional Trial Court Branch 13's joint decision. Andrea's execution of deed of absolute sale is on behalf of Rosa Elsa in favor of spouses but was void and unenforceable as the authority to represent Rosa Elsa had already been revoked as early as October 10, 1996. Petitioners posit that the deed must be recognized and enforced for the reason that, despite the revocation of the authority of Andrea prior to the execution of the deed, they should not be bound by that revocation for lack of notice. Consequently, they contend that as far as they are concerned, the contract of sale should be given effect for having been executed by someone appearing to them as authorized to sell. They further argue that the failure of Rosa Elsa to register, file, and enter the deed of revocation in the Registry of Deeds did not bind spouses but under Section 52 of the Property Registration Decree. It is their position that without the registration of the revocation, they cannot be bound by it, and the court must respect the sale executed by her agent Andrea. Issue: whether or not the revocation of the SBA, despite lack of basis, enforceable against third persons is in accordance with law. Ruling: the court denies the petition. The court agrees with the Court of Appeals that the genuineness and due execution of the deed of sale in favor spouses but were not established. In the case at bench, it is on record that it had no copy on file of the deed of absolute sale. Article 1358 of the new Civil Code requires that the form of a contract transmitting or extinguishing real rights over immovable property should be in a public document. Not having been properly and validly notarized, the deed of sale cannot be considered a public document. It is an accepted rule, however, that the failure to observe the proper form does not render the transaction invalid. Without the presumption of regularity accorded to the deed coupled with the default of the party relying much on the same, the purported sale cannot be considered. It is as if there was no deed of sale between spouses Bitte and spouses Jonas. The genuineness and due execution of the deed of sale in favor of spouses Bitte not having been established, the said deed can be considered non-existent. Granting arguendo that the deed of sale may still be considered, the transaction is, nevertheless, unenforceable. In the case at bench, records show that spouses Bitte initially transacted with Andrea as Rosa Elsa's agent on the basis of the special power of attorney, dated July 19, 1985. Thereafter, however, Rosa Elsa returned to the Philippines and directly negotiated with them on October 11, 1996. Rosa Elsa's act of taking over in the actual negotiation for the sale of the property only shows that Andrea's authority to act has been revoked pursuant to Article 1924. At that point, spouses Bitte had information sufficient enough to make them believe that Andrea was no longer an agent or should have compelled them to make further inquiries. No attempt was shown that spouses Bitte took the necessary steps to inquire if Andrea was still authorized to act at that time. Despite their direct negotiation with Rosa Elsa, they still entered into a contract with Andrea on February 25, 1997. Considering that the sale was executed by an agent whose authority, be it actual or apparent, had been revoked, the transaction is unenforceable pursuant to Article 1317 and 1403(1) of the Civil Code. Considering that the deed of absolute sale was executed at a time when spouses Bitte were deemed notified of the termination of the agency, the sale must be treated as having been entered into by Andrea in her personal capacity. One can sell only what one owns or is authorized to sell, and the buyer can acquire no more right than what the seller can transfer legally. Accordingly, spouses Bitte acquired no better title than what Andrea had over the property, which was nil. In sum, the deed of absolute sale executed by Andrea in favor of spouses Bitte is unenforceable against Rosa Elsa because of their notice of the revocation of the agency.